Although the majority in the civil rights cases held that the provision at issue improperly governed private conduct, Justice Harlan's dissenting comment about private activities that were heavily intertwined with government functions found its way into a line of cases holding that private activities can sometimes provide a public function subject to constitutional civil rights guarantees. In March v. Alabama in 1946, for example, the court held that company towns, that is, towns established and owned by private corporations, for example by industrial mines, where employees and their families can live, serve public functions and must comply with constitutional First Amendment guarantees. And a group of cases in the 1940s and 1950s, including Smith v. Allwright and Terry v. Adams, upheld constitutional challenges to white primary political party candidate selection processes held in private venues such as restaurants and golf clubs that excluded black patrons. However, the court subsequently declined to find state action in a number of other contexts, effectively confining the public function cases to the company town and white primary contexts. Private agreements ordinarily are not scrutinized on constitutional grounds, much less on equal protection grounds. The freedom to contract means that individuals and private entities can choose with whom they wish to enter into agreements for just about any reason at all. Of course, civil rights and other statutes might restrict some kinds of agreements, and some kinds of agreements might also be held unenforceable on grounds of public policy under contract law. But these are not directly constitutional claims because there is no state action. However, it is also true that contracts must be enforced by courts, and the Supreme Court has held that for certain kinds of contracts, the involvement of courts can comprise state action triggering constitutional scrutiny. This theory was developed in Shelley v. Kramer, decided in 1948. That case involved racially restrictive covenants in real estate deeds. Such covenants were a common way of encoding segregation through private agreements. The court held that judicial enforcement of such covenants was a denial of equal protection. Cases decided after Shelley v. Kramer, however, have been inconsistent. In Evans v. Abney, decided in 1970, the court addressed a conundrum caused by a provision in the will of former Confederate soldier and later U.S. Senator Augustus Octavius Bacon of Georgia. Bacon's will left money to establish a park for the sole, perpetual, and unending use, benefit, and enjoyment of the white women, white girls, white boys, and white children in Macon, Georgia. The money was held in a public trust, and the park, Bacon's Field Park, was built after Bacon's death in 1914. Litigation over use of the park arose during the civil rights movement in the 1960s. In 1966, in Evans v. Newton, the court held that a park administered by a public trust for the benefit of white people violated equal protection. Litigation then ensued in state court over the status of the trust funds. The state court held that the purposes of the trust had been frustrated by the court's holding in Evans v. Newton, and that the trust property, including the parkland, therefore reverted by operation of law to Bacon's heirs, resulting in the closure of the park. In Evans v. Abney, the U.S. Supreme Court upheld the state court ruling. The court held that the Georgia State Court was merely applying settled trust in a state law, and that the resulting closure of the park was not a form of state action. In Burton v. Wilmington Parking Authority, decided in 1961, before the Civil Rights Act of 1964, the court stretched the state action doctrine to its breaking point in upholding an equal protection claim against a private coffee shop located in a public parking facility. The court reasoned that since the parking facility was publicly owned and performed essential government functions, and the coffee shop leased its space from the government, there was state action sufficient to support the equal protection claim. In contrast, in Moose Lodge v. Irvis, decided in 1972, the court held there was not sufficient state action to sustain an equal protection claim against a private club merely because the club held a Pennsylvania state liquor license. Similarly, in Reitman v. Mulkey, decided in 1967, the court found sufficient state action to sustain an equal protection claim when California voters repealed existing fair housing laws through a ballot initiative. The state and the dissenters in this 5-4 decision argued that a decision by voters at the ballot box could not be considered state action, but the majority focused on the structure of the ballot and the state's ongoing role in unwinding existing fair housing laws. In contrast, in Jackson v. Metropolitan Edison Co., decided in 1974, the court found no state action when a private company regulated by the Pennsylvania Public Utilities Commission allegedly terminated a customer's service without procedural due process. As this sampling of cases illustrates, there are cases in which state action can be found based on judicial enforcement of private agreements, private use of government property, or a governmental regulatory scheme. But the circumstances under which this might obtain are unusual. In general, the American approach to constitutional rights is mostly vertical, that is, between the state and the individual, unlike the European approach, in which constitutional rights provisions also often apply horizontally between private individuals. For the most part, if society wants values such as racial equality to apply in private transactions and private spaces, the law can only address this concern through statutes and regulations.